Holders of XRP, I have some shocking information to share about some of the biggest players out there. In this case, Bank of America. We've been hearing about Bank of America for a long time, since around 2018 or 2019. And they're still one of the biggest banks out there, and they're at the top before, right? Not only that, but they're also still waiting for something big to happen. And it feels like that big event is about to happen. We should talk about this, especially with some of the new information we got our hands on. With that out of the way, welcome back to the channel, everyone. My name is Johnny. For those who are new to the channel, hopefully through the end of this movie, in the end, you do become a member. Let's get started with this, but up here from John Edian1, he said that Ripple didn't put going public at the top of its list of priorities because that didn't make sense under the previous SEC leadership. That might change in the future. This comes from Brad Garlinghouse. I already said that I agree with the idea that Ripple will go public either in the last quarter of 2025 or in the first half of 2026. When it happens will depend on how tough Paul Atkins is as SEC head. I don't think the case will be thrown out. They can pay the fine and the case is over. This could happen in the first sector if Atkins is shown quickly, but it's more likely to happen in the second sector if Washington moves slowly. Since the attraction could be taken away, he doesn't see any reason for the SEC to appeal Ripple's ruling. And if they do overturn attracted, that could only bring bad news about the SEC as an organization. The only reason the SEC filed an appeal was because people who tried to charm her and her minions got their feelings hurt by getting kicked in the balls by Ripple and the 75 no more P holders. For more than one reason, the argument doesn't make sense. First, the TOR's choice is a decision made in a federal district court and is not binding law. Number two, the Ripple ruling doesn't set a very strong standard. In fact, Judge Torres, who is also a district judge in the same SDNY district, has already pushed for and against it. A number of criminal law students and other experienced intelligent security lawyers have also said bad things about it. Even well-known financial reporters have said the pick was bad. Third, Judge Torres made her ruling very fact-specific, which means it only applied to the events of the Ripple case. So because of this, the choice itself is not very convincing. Also, when she turned down an interlocutory appeal, Judge Torres made it clear that her ruling did not change the fact that all secondary market sales of virtual goods could not be considered sales of securities. She said that the SEC's evidence or lack of evidence about secondary sales of XRP in the Ripple case did not meet the Howey test anymore. Cases with big criminal questions or decisions that differ from one circuit court to the next are taken by the Supreme Court. An example of this would be Rakoff ruling versus Torres ruling. Because of this case, the decision could be very important from a legal point of view, and because these virtual reality items have become so well known, I don't think it makes sense to apply laws from the 1930s to modern technology. 14th parallel. There is a good chance that the Supreme Court will hear the case. You should think about it because there is up-to-date information on value. But I think it's safe to say that the 11 billion could be very old at this point. We now have more than 100 billion XRP, which is a lot of money. You know what else? One thing I can't quite wrap my head around is how Ripple is traded on the secondary private markets at a huge discount to its net asset value. Some people might say that the micro method is similar in some ways, but it trades at a rate that is, I guess, 3 times the price of an internet asset. You think it might be a fun? To go over it again, I guess what antimicro method, I hope it's a big deal and that they keep doing what they may be doing, that Ripple has been in a state where going public has not been a top priority. That did not make any sense to the people who ran the SEC before. That might be why we need to change the course of our lives, that we'll compare that as things go on. I mean, listen, it looks like he really wants to say, hey, keep your mind on the task at hand. It's going to happen. At this very moment, I think Brad is very excited about what is about to happen. Why? Well, since it seems like the case is about to end, I really believe that we are about to see the whole show and the end, and then nothing will happen. But great steps are being taken to help Ripple or even XRP grow in a big way. For example, as a lawyer named Jeremy Hogan, I've said a lot about the Ripple case over the last 4 years. No matter how many hours of video, pictures, reviews, and studies are done, it doesn't matter because once more, that is Brad and Sir Al Rady meeting with Donald Trump. I already told you guys about this. This is the story of Johnny Dean. A man named Johnny Dean had to take a picture in front of the SEC Gov building, even though he wasn't in town. In case you're wondering, no, Chair Gensler didn't ask us in. Outside of the SEC, this is how it looked by the end. That came from Johnny Dean. It seems like this case is mostly over, so it will be put behind us after the 20th. Why is that so important, and why did I assume you already knew big names like Black and Bank of America? So let's fast forward to July 17th, 2023. That's when Ripple says US banks will have to use the XRP cryptocurrency after they partially win their fight with the SEC. Keep in mind that this is going to happen again in 2023. They said US banks were clear. It wasn't just banks in the area. It turned out to be US banks as well. This could be really exciting, okay? Now, this could be very exciting because what US banks are they talking about? Yes, we know that Bank of America has a